Good morning, everyone. In History of the United States Constitution, today I thought I would post a video on really an odd assortment of articles or amendments in the Bill of Rights that don't jive well together necessarily. And I don't think they're small amendments or should be looked at as de minimis, but in terms of our everyday dealings in the events of human affairs, if you will, these amendments are just more likely to be narrow in scope. And so I thought I would put them together in one, what I consider to be a little bit more of a neater fashion than to treat them independently or to incorporate them with other amendments. They are not necessarily related. It's just in terms of chunking out information in a digestible way, I thought I would group the Second, Third, Seventh, Ninth, and 10th Amendments together in one area. They are not necessarily related in any way, shape, or form. But we have to go through the Bill of Rights in some kind of logical progression. And I don't want to spend a whole unit on just the Second Amendment or the Third, the Seventh, Ninth, or 10th. And I thought the sort of the complexity and the nature of the amendments allowed and alluded to putting them together in one unit, although disjointed. So, if that wasn't clear, I don't blame you for having that interpretation. But anyways, the Second Amendment, let's start off with the right to keep and bear arms in a well-regulated militia. I'm not quoting the amendment directly there, but you get the basic idea of it right from the language, that the debate often stems on whether or not the right to keep and bear arms is dependent upon the clause that the amendment starts with, in a well-regulated militia. Today's militias are the National Guards of each state. Do you have to be in the National Guard in order to basically bear arms, to possess armaments? Or could the government curtail those interests and rights? Well, that debate has been somewhat settled, and not by the people, not by voting or referendum, but by the courts. And the Supreme Court, like we know through the power of judicial review, tells us what the Constitution means. They're the final arbiter of what this document gets interpreted as. And if we don't like it and a significant number of states and citizens get together, we can overturn a decision by constitutional amendment, but we know that's very rare. So the Second Amendment doesn't require us to be in a well-regulated militia in the sense of a modern militia's makeup is. What it does require, or what it has been interpreted as, is the well-regulated militia in the area or era in which it was written was basically everyday citizenry would get up and take arms against threats. And therefore, looking at the amendment in the era in which it was written and looking at the contextual dialogues that were going along with it in the Federalist Papers and in the framers' mental makeup in terms of letters and historical precepts that existed at the time of the adoption of the Constitution, the Supreme Court has told us there was an expectation the right to keep and bear arms isn't necessarily regulated to a militia or the military, but it's an individual right. Now, the problem with that, and I think the interpretation tends to be knee-jerk among many people that think that the government just can't interfere. We have an inherent right to keep and bear arms. Well, that's true, but like any right, even the First Amendment right to free speech and freedom of religion, we know is subject to some forms of government interference and curtailment in order for us to maintain a civil, balanced, and safe society. And what those balances are aren't always clear. But the case law is very important to study and talk about just briefly here. In the main one, it really came down in very recent times, and that's the District of Columbia versus Heller in 2008. And that basically made the Second Amendment applicable to the states. Remember, through the concept of incorporation, we have not always had the Bill of Rights be applicable to state action. It was only through the power of incorporation through the 14th Amendment were the other Bill of Rights applicable to the states, and the Second Amendment finally was in 2008 in the Heller case. But basically, Heller had how it was the District of Columbia banned basically any form of handgun ownership carte blanche. It was just too strong a ban, said the United States Supreme Court, said that the government, state, local, federal, does have an interest in regulating guns and arms, but it can't do carte blanche banning of it because it's a fundamental right incorporated in the Second Amendment. So do we have certain curtailments to this day? Yeah, although you can get a machine gun license in Massachusetts, it's very, very narrow in terms of the application of the kinds of machine guns that can be possessed, and it's very few citizens actually get that type of licensing. But generally, licensing, for example, is one curtailment. Only certain people can get licensing. Sometimes governments have been upheld, meaning state governments have been upheld, local governments have been upheld in requiring certain safety training prior to licensing occurring. Also, denying people with certain criminal past or instability with mental health regards can be banned from potentially owning and possessing certain weapons legally. There's also certain types of weapons that are banned in certain jurisdictions. For example, in the state of Massachusetts, to have a high capacity weapon with more than 10 rounds in a magazine has generally been deemed to be banned, and there's been no constitutionally successful challenge to that. There is ways around it. Basically, there's a grandfathering provision that if you had a pre-banned either weapon or magazine, that's deemed to be a valid possession. So there's a huge market in pre-banned products. But think about it. It's kind of a common sense principle. Once the court is established, there is an inherent individual right to keep and bear arms. The only test after that, and it's going to be constantly ironed out through legislation and court review, is how much curtailment can the government do, if it wants to do it, in the way and methods in which non-criminal, competent citizens possess weapons. Can I own a small nuclear device on my own? Can I own poison gases? Can I own hand grenades? Can I own a tank? Can I own, a fully automatic, meaning fully fires multiple times just to pull upon one trigger, just pull it back? Does the government have an interest in banning that? I think there is a strong argument that they do. How far can they go is going to be the constant test, ebb and flow back and forth. I think some of you might be doing your paper on the Second Amendment right to keep and bear arms and the history related to that. I can tell you, I think I'm a kind of a moderate on this issue. I am a gun owner. I shoot fairly regularly. And so I have friends of mine that are real zealots over this question. Anytime they hear about something coming up about potentially curtailing the types of weapons or maybe the type of armaments or whether we have to register our actual bullets, and whether there be certain safety provisions on guns, that they really get up, no, actually, pun intended, they get up in arms over the question. But I tend to be a bit of a realist, and I recognize that the government probably is going to have some ability to curtail and infringe upon that right, as provided it doesn't go so far as to violate the fundamental right to keep and bear arms for certain, we don't want 7-year-olds running around guns, so sometimes there's age requirements. We don't want people that committed maybe certain violent crimes, but who determines that? It's going to be the government, and people will challenge it along the way. It will determine how far and under what circumstances it'll go. I know I have a friend of mine, I tease him all the time, because some people think the Second Amendment is antiquated and it should be abolished. We should amend it to basically allow government to curtail it to save lives, because we have all these tragedies out there. And I often said John Paul Stevens was the former justice that said, the Second Amendment is what's basically hurting society by allowing so much gun ownership of such a wide variety. And I send that article to my friend from time to time after we go to the range, because he gets so bent out of shape over it, because he's concerned. He loves his guns and he doesn't want to lose them. The good news for those of us that are gun owners, I don't think we're going to ever lose the entire right to own guns, but will there be limitations potentially on the nature, maybe even the amount of ammunition you keep at any given one time? Maybe. And it's going to be constantly an ebb and flow. And like any rights, any liberties that we hope to have preserved and or curtailed, depending on what side of the argument you're on, we know it's the court that's ultimately going to decide. Sorry to ramble there, but the Second Amendment isn't always exactly clear. And people look to things like not just the Constitution first meaning, but what the intent was based upon the writings that were contemporaneous with the adoption of the amendment. And if you look at the Federalist Paper number 647 by James Madison, the advantage of being armed when the American possesses over almost every other nation, meaning that the ability to remain armed, some people believe, keeps us from tyranny. The government won't be able to invade in other fundamental rights. Some people see the Second Amendment as so fundamental to all other rights because in order for us to retain sort of individual freedoms and liberty, the ability to be armed is what keeps us from having a tyrannical government basically sieging upon us as puppets of a rogue regime, if you will. I don't know if I buy that entirely, but it's an interesting argument. I don't want to say that's it for the Second Amendment. It's huge, and it's ongoing right now. There's going to be new legislation from time to time, either on the state level, the federal level, with certain kinds of issues over guns and ammunition and things like that. And there's going to be real questions of challenge. And what you need to know is the court determines it. And that's part of the reason why I think when people vote for the president or for a governor, you know they're going to appoint people to the courts that are going to have certain views and opinions. And that's why well, I'm not huge on the Second Amendment. I'm kind of like what I consider to be a moderate on the issue. But those of us, like my friend, Second Amendment, he will only vote for candidates that, I hate to say it's his life, but it's a big part of it, because he wants to shape policy through judges. And it's fascinating. Third Amendment, very quick. We know during our revolutionary history that British soldiers were quartered in, largely, it happened in New York too during other conflicts, but especially right here in Boston, Massachusetts, they were quartering British soldiers in colonists' homes for no fee, meaning you had to let soldiers come in your house. You actually had to feed them. And they often, when they were off duty, this is kind of way outside the scope of the book, but it's one of my favorite topics in history. These people would actually go out and find part-time jobs that actually competed with the homeowners that were, earning their wages just to keep their home. So it was considered very, very despised, the quartering of soldiers in a private citizen's home without consent. And it was such a bitter pill that after the Revolutionary War was successful, they wanted to make sure that was incorporated in document. That's the Third Amendment, no quartering of soldiers in peace. In fact, it's one of the concepts of why a standing army has been oftentimes, after World War II it happened, but prior to that, we actually had a very minimal military existence on an ongoing basis, because the fear of standing soldiers is like an extension of potential tyranny by the federal government, and the quartering of soldiers needed to end. And that's all the Third Amendment is. It hasn't been tried at all. There's been no case law, although it's been referred to in other cases when we're trying to find a concept of privacy, or even though the Constitution never says privacy anywhere in any of the language, but we all expect that to be part of our civil liberties, to have a basic expectation of privacy against government interference. We look to the Fourth Amendment, but we also sometimes cite the Third Amendment, the courts do, saying that the concept of even banning the quartering of soldiers in private citizens' homes without their consent is consistent with the view that that's obviously protecting that unenumerated right that we all believe in, and that's the right to privacy. So, we'll do the fourth, fifth, and sixth and eighth as separate, all dealing largely with criminal justice. So now I'm going to go to the seventh. If I spot an attorney or someone that went all the way to law school and I said, tell me what your favorite part of the Seventh Amendment is, I bet you most people can't even say it that are lawyers. So it's not that it's a forgotten amendment, but we take it for granted, kind of like the Third Amendment with quartering of soldiers. It just doesn't come up that much. But the Seventh Amendment was written to make sure we preserved the right to jury trials outside of the criminal realm. It's the third time it's mentioned in the Constitution, but here it's specifically for civil complaints. Those are torts, contract claims, things like that the citizens have a civil right that's protected by the government, civil liberty, to have jurors determine the outcome of those cases in terms of fact. The judge always is supposed to instruct on the law, but juries are the sole determiner of fact. Now, they put in there that it had to be recognized at common law, meaning if a new novel type of action, private action, comes up, you may not necessarily have a right to jury trial if it wasn't recognized at common law at the time the Constitution was written. And of course, the very archaic concept that it had to be worth $20. In 1791, big deal. Today, $20 seems quite trivial. But you have a right to a jury trial in civil matters, state, federal, or otherwise, if the claim was recognized at common law that they did jury trials in those kinds of cases, and the claim is worth more than $20. Now, things that weren't recognized at common law to have a jury trial right are like divorce proceedings. That's not done in front of a jury. That's done every so often because someone can't wait to get in front of the jury and I can show evidence of how bad, my wife is or my husband is or something like that. So we're not going to get a jury. He goes, I thought I had a constitutional right to a jury. Now, they weren't recognized at common law, so states, as long as they follow some kind of system of due process, fundamental fairness, doesn't require a jury trial. Workers' comp's another example. You get in front of an industrial accident board because workers' compensation didn't exist back in 1791. But generally speaking, you have a right to a civil jury trial, just like you do in a criminal trial, in most circumstances that we traditionally think as private obligations. Another difference is not on the federal level. On the federal level, jurors have to be unanimous on their verdict, whether it's for plaintiff or defendant, and in criminal case, whether it's for the government, the government versus the accused, has to be unanimous. Most states, some states do have unanimous requirements in civil, many don't. They don't have to have a unanimous verdict. And there's different standards of proof. Proof beyond a reasonable doubt in criminal case. Civil case is a preponderance of the evidence, sometimes clear and convincing evidence, depending on the kind of case. I'm way off track. Seventh Amendment, it preserves a right to have jury trials in most civil matters. Now the Ninth Amendment, the sleeping giant, in my opinion. But boy, is it a controversial amendment in many scholarly areas when you talk about it. And I love the language of it. It's kind of like the framers were smart, saying, hey, wait a minute. When we list all these amendments, all these civil liberties and civil rights, and we're listing them all, but we aren't listing them all. We recognize when we start listing things, that didn't mean we didn't include other things that are so inherent to natural and unalienable concepts that those are preserved to the people. And how the language actually reads is the enumeration in the Constitution, meaning the listing, the explicit listing of certain rights, shall not be construed to deny or disparage others retained by the people. It's kind of like when you say the following things are included, but not limited to, because you want to give a list to give a flavor, but there's many more rights. And that's where often people, I think the Ninth Amendment can be used expansively by the court to find privacy rights against government interference. But a lot of scholars say, well, you can't just say it's kind of a catch-all or the court, whenever it wants to, can create a right out of the air. That is giving the courts way too much power for an unelected branch of government to have this sort of mysterious grant that some rights weren't listed, and this is one of them, we're just going to make it up. It usually has to be consistent with things that we find in history. But the amendment has never been cited directly, other than one, I think, very famous case, and that's the Griswold case, where contraceptive devices were illegal right into the 1970s, even for married couples. And not that I should make any difference, but back then, you think in a married couple, you can't have contraceptive devices. So this woman, who I think was an editor of the Hartford Courant, challenged it by purposely going and buying contraceptives, and she gets a $50 fine or something like that. She challenged it with the Supreme Court. The Supreme Court said, although there's no specific discussion in the Constitution about people being able to control the reproductive processes, there's an inherent privacy interest found in the Ninth Amendment. But it also mentioned other amendments like the First Amendment and the Fourth Amendment. So it wasn't like the Ninth Amendment standing alone has ever had a lot of gravity. In fact, a lot of people make fun of it. And if I were ever on the Supreme Court and someone says, if I was on the Supreme Court, I probably would use the Ninth Amendment where I deemed appropriate. But if I was in a conversation with people as a scholar and I said, maybe we can find a Ninth Amendment, I think I'd get laughed at a little bit. It's kind of the forgotten amendment. But I see it as a sleeping giant, where if the court inherently knows there's wrong or there's some kind of way in which we must protect individuals from an unwieldy government, I think the Ninth Amendment's ripe for the picking. Pontificating a little bit. I always thought that when I as a student studying the Ninth Amendment, I said, why isn't it being used more? And I think that's what a lot of scholars ask. Why isn't it being used more? And some people say it's because of judicial restraint. You shouldn't use a tool that's not really identified, and it's too open-ended. And if we start using it like that, the courts will tilt the constitutional sort of checks and balances between the three branches of government if they sort of have this wild card Ninth Amendment that they can pull out. So it's rarely been used. 10th Amendment. 10th Amendment we fought a civil war for. Arguably, our Constitutional Convention in 1787 down in Philadelphia, much of the debate was over the concepts in the 10th Amendment, and that's the sort of sometimes called the reserved powers provision. Basically, it says the powers not delegated to the United States, basically not given to the central national government by the Constitution, nor prohibited by the states, meaning states weren't banned from using it, are reserved to the states, respectively. What people were concerned with even after the adoption of the Constitution, the checks and balances and the Enumeration Clause in Article 1, Section 8 of the United States Constitution, giving powers to the Congress, there was still a real fear among many states that states still wanted to be a player. They wanted to have this sort of dual sovereignty with the federal government in certain spheres, and they didn't want it to not go articulated a second time, even if it's not. I think it's implicit in a lot of people said it wasn't needed because it's clearly a government enumerated powers on the federal level. Clearly the states retain a lot of power. A lot of people weren't happy with that. So we want to listen. We don't trust you. And that's the goal of the 10th Amendment, to reserve state powers, that the states have a sphere of influence and power within the federal government, and it needs to be honored and recognized. But what that means and when the federal government will be dominant, with the states will be dominant, or will they be co-equal on certain things, remained a huge debate, and even debated today. We know the biggest debate came about as a result of the Civil War, but before the Civil War, going through a little history, it is the history of the Constitution, there were some, including our framers, Thomas Jefferson and James Madison, said if the federal government appears to have gone beyond the control or powers by which it was given in the Constitution, states are free to nullify and disregard the federal law as contrary to the state's interpretation of the Constitution. And that came over the Alien and Sedition Act. Basically, there was a federal law that says you can't criticize the federal government. It was aimed at people like Thomas Jefferson and James Madison that were critical of the Federalists, guys like John Adams. And people are getting locked up for criticizing the government. And he goes, you know what, these laws are so repugnant. They respectively had power in the states of Kentucky and Virginia. They got the state of Kentucky and Virginia to pass this resolution nullifying the enforcement of the Alien and Sedition Act, basically saying federal law doesn't apply here because it's unconstitutional in our interpretation. It's a precursor, and these words tend to haunt us. We like it when Thomas Jefferson and Madison said it. There was no real outcome from it because Thomas Jefferson gets elected a year or two later. The Alien and Sedition law has a sunset provision. It's gone, so the controversy's over. But the words of Madison, the words of Jefferson in the Kentucky and Virginia resolves are the words of whom? The Southern separatists that caused secession from the United States because they're saying federal government's overreached. We are a free association of states in a union. We have every right to join. We have every right to walk away. And they cite the 10th Amendment over and over again. The 10th Amendment, we fought it over slavery, but it was the vehicle of slavery was definitely the issue. Don't get me wrong. But it was, can states determine whether or not slavery should be illegal or illegal, or should the federal government be able to determine for a state? And that was a very, very controversial aspect. I know it's bigger and broader, and I'm simplifying the argument, but states' rights versus federal government is a very, very big tension that we've had in our country. It was largely resolved because of the Civil War. Federal government clearly dominant. It was even resolved, I think, somewhat before that in some realms, especially related to commerce. We know because of John Marshall stating that the Commerce Clause and the Necessary and Proper Clause gave a lot of less elasticity to the federal powers, and the states we know have to what? Because of the Supremacy Clause, states have to bend to the federal will when the federal government does have power. But a lot of states don't buy that, and that was a bone of contention. And we know we almost had we had the Kentucky and Virginia resolves, and then later we have the nullification crisis in the 1830s when there was a very high tariff in South Carolina. It says we're succeeding. We're going to nullify that federal law. No one's going to collect that tariff, and we're going to break away unless you do something about it. And that was Vice President Calhoun, who left the vice presidency basically to go back to South Carolina and fight for the South Carolinian rights under state law concepts. And the nullification crisis almost led to the Civil War earlier, but not over slavery, but over tariffs. And Andrew Jackson mustered up the military, and they're about to invade into South Carolina. South Carolina mustered up their state militia. They were ready to go to battle, and it came that close until they passed a modified tariff, basically quieting the controversy in South Carolina. And there's a recognition South Carolina was about to be invaded by federal troops. They had a short-lived peace from the 1830s until 1860. And then the second nullification crisis, the succession crisis, comes over slavery. But boy, we still talk about the 10th Amendment to this day. It's coming up over, going back to the Second Amendment. There's federal laws trying to do certain things with guns and bullets and all these other things. Some states are saying, oh, you can do just the opposite of what the federal government's going to mandate under this new federal law, because under state rights, we're not going to impinge upon the rights of our state citizens to keep and bear arms. So this tension is constantly going over and over again. And how do we know how to resolve this? We look to the Supreme Court. And it ebbs and flows. We know Marshall was a nationalist, and he was for national domination and state subservient. But Marshall's predecessor, or successor, I should say, is a guy by the name of Roger Taney. That's how you pronounce his name. Roger Taney is the most infamous for making the decision of the Dred Scott decision, basically saying African Americans really aren't even human and therefore have no rights, and are certainly not citizens, and they are merely property, and therefore they can be transported to any state in the union, whether free or slave, and they still remain in bondage. They still remain slave because the federal government doesn't have the authority to curtail on property rights in that realm. So Roger Taney was a huge states' rights guy, and he believed in something called dual sovereignty. Basically, there's federal power and there's state power, and in their specific spheres, they are omnipotent. They are mutually sovereign. They are mutually power brokers in their realm. And sometimes their realms overlap. And if they overlap, we know there's federal supremacy. But Roger Taney thought there were some things the federal government just shouldn't be involved in. And if they're not, then states have supremacy. And it's ebbed and flowed throughout time. We know the Rehnquist court, Justice Rehnquist, was a big curtailer of federal interference in traditional state activities. So state rights have actually grown, not initially after the Civil War, they were kind of crushed, but over time through court interpretation and through policies of the government, states' rights have ebbed and flowed vis-a-vis federal power. And I was just looking at one section here that was really interesting. There was a nice numerical thing about actual numbers over the time, how many cases were shot down. Yeah, it says right from 1995 to 2002, in my opinion, recent history, when you think of constitutional history, the court has consistently curtailed federal authority, striking down more than 25 laws enacted by Congress. And if you look at an earlier era, from 1937 to 1995, the Supreme Court overturned just one federal law, saying it exceeded the Commerce power. So we ebb and flow in terms of state rights versus federal domination, and back and forth. And who do we look to answer that question? The Supreme Court of the United States, or the federal courts, but eventually gets the Supreme Court. We want the Supreme Court to resolve it, so have uniform principles between state and federal law. But again, we know Ronald Reagan actually ran it and called it the new, what did Ronald Reagan call it? The new federalism in the 1980s, to reduce the size of the federal government and give more control, more power, and really more governance should come from the state government and not from the federal government. One smaller federal government. One of my favorite quotes in there, President Bill Clinton declared, "The era of big government is over." It's a nice slogan, but it's hardly true. And then we know George Bush and Barack Obama both expanded federal power significantly, so it ebbed back towards federal domination again. But we know there's pushback from that. So when the federal power grows, there's the groups, the Tea Party and the libertarians and the like. They want to push back from federal domination. They want local rule in a very small way, because they don't want too much government involved in life. And they gave an image of Ron Paul, who said succession, or the argument of succession, is very patriotic. That's exactly what the Revolutionary Patriots did. We honor them, but to say it today shouldn't be antithetical to being a patriot, is his argument. Ron just recently not too long ago, had a heart attack. He's getting old. He's out of the Congress now, but he actually said those things while he was a congressman from Texas. His son's now a senator from, I believe, the junior senator from Tennessee. And they are big believers in very small federal government and more prominent roles for state government when there needs to be government, if at all, in these circumstances. Hey, I was kind of all over the place, but kept it fairly short, though, for several amendments. Just trying to do a quick little summary. I'll make a little minor assignment related to it, and that's the 2nd, 3rd, 7th, 9th, and 10th. All important, but in terms of the big vehicles of things you're going to deal with as police officers, school teachers, and citizens, the amendments that really carry the day are the 1st, 4th, 5th, 6th, and 8th. And we already did the 1st, and the next sort of chunked out bit of information are going to be what I call the criminal procedure rights protected by the 4th Fifth, Sixth, and Eighth Amendments. Otherwise, it was very, very curt, very superficial, very summarial in fashion here. So it's just a quick, brief little discussion. Don't be afraid to reach out and ask questions. The book is very, very good and very concise. And I'll give her kudos for that, because it's a survey course. We don't want to get too deep into the thicket and get confused. She spells it out in a very nice, clean way. And if you understand the concepts in the book, you're well on your way to being, I think, a pretty decent constitutional scholar on the status of what these amendments mean.